Good day, everyone, and welcome. My name is Dan Sampaio, and it's my pleasure to open today's Mondac webinar in association with William Fry, which will focus on the changing employment and pensions landscape in Ireland. Before I hand over to our wonderful panel, a couple of housekeeping items. You have the opportunity to submit questions using the questions tab in the toolbar on the right-hand side of your page. We will endeavour to answer as many as possible, but any we don't get to will be sent on to the panel, who will be in touch. This session is recorded and you will receive an on-demand version along with the slides in the coming days. Now it's my pleasure to hand over to our panel. Thank you.
Thank you, Dan. And thank you everybody for joining us today. You're all very welcome. Thanks also to Mondac for facilitating the webinar. It's always great to work with Dan and the team. To introduce myself, my name is Catherine O'Flynn. I'm the head of the Employment and Benefits team in William Fry, and I'm the current chair of the Employment and Equality Law Committee in the Law Society. Some of you may have joined us at our last webinar with Mondac, which was last November, which is hard to believe. At that stage, we were just coming to terms with the pandemic somewhat in relation to work anyway, and we looked at the topics of working from home and remote working, and we discussed those topics from the perspectives of health and safety and employment law and tax and privacy. So now this is 7 months later, and we're all very happy to say that there is light at the end of the tunnel. Vaccinations are being rolled out, and we are now looking at the return to the physical workplace, which is great. But of course, the world of work has changed, and employees' expectations have certainly changed. Coupled with that, then, there have been a number of legislative developments, both in the employment law world and in the pension law world, that employers need to be mindful of. So the purpose of today's webinar is to bring you all right up to date, and also to highlight some new employer obligations that are in the pipeline, and we really hope that you find it of some use to you. So to introduce my colleagues, I'm very happy to introduce Emer, who will be speaking to us first. Emer is an associate in our Employment and Benefits team, having trained with the firm, and has experience in both contentious and non-contentious employment law matters, including advising on the employment aspects of M&A transactions, employment contracts, and terminations. Emer will be focusing on the employment law updates so far in 2021. And I think her main takeaway will be that there has been a lot of movement in this area and a lot of developments in the pipeline. Ciara then is a senior associate in the pensions department. Ciara has over 11 years of experience in pensions law and has worked in both London and Dublin. She's a wealth of experience advising trustees and employers on pension aspects of corporate M&A transactions and advising on potential issues and solutions where pension liabilities may arise. She advises on the day-to-day management and administration of schemes and pension disputes. Ciara is a council member of the Association of Pension Lawyers in Ireland and a member of the UK Association of Pension Lawyers. Ciara is going to be running through the new Irish pensions regulations, which have transposed the EU directives IWRP 2. She will explain how trustees and employers of occupational pension schemes can comply, and will discuss the key points of concern which pension scheme trustees and sponsoring employers will need to be aware of. Last but by no means least, we have Richard Smith. Richard is an associate in our Employment and Benefits team and has experience advising clients on a wide range of employment matters, and also specialises in immigration law issues. Richard will be looking at recent guidance issued by the Irish government and the Health and Safety Authority about COVID-19 and minimising risks associated with the virus in the workplace. Richard will then examine recent and upcoming developments relating to remote and flexible working. Very topical issues, I'm sure you all agree. So without further ado, I'm very happy to pass over to Emer.
Thank you very much, Catherine. So as Catherine has stated, I'm going to be discussing recent and upcoming employment law developments in 2021. I'm going to do this by looking at 3 developments that have already happened this year, and 3 that are in the pipeline for the second half of the year. So first up, we have the prevention and resolution, the code of practice on the prevention and resolution of bullying at work. So this code was joined by both the WRC and the HSA. The WRC, a term you'll be hearing quite a lot today, is the Workplace Relations Commission. And these are a semi-judicial body which promotes and governs employment rights in Ireland. And the HSA are the Health and Safety Authority, which ensure that workplaces are complying with health and safety standards. So what this code of practice did is it provided very useful guidance to employers. First of all, it provided the definition you'll see on your screen, which defines bullying as repeated inappropriate behaviour in the place of work during the course of employment that undermines the individual's right to dignity at work. What this code further did was it provided a non-exhaustive list of behaviours that count as bullying and behaviours that don't count as bullying, which is very helpful to employers. So example of behaviours that count as bullying are social exclusions, blaming employees for things that are out of their control, or micromanaging work to an extreme extent. Examples of behaviour that don't count as bullying is regular performance management or even strong difference of opinion. So the purpose of this code is to provide guidelines to employers on how to prevent bullying and also what procedures they should have in place if a bullying situation arises. Now, this code is not legally enforceable for employers, but it is our strong advice to all employers to make sure that the code of practice is up to date, because failure to implement these codes can be used against an employer if an employee was to take a claim to the WRC. Next up, we have the Oversea case. So this case in 2021 caused significant alarm amongst the employment law world in Ireland. So what happened was, just to give you a brief overview, is that the CFO of a company was dismissed during his probationary period for poor performance. This is quite a standard scenario, but what caused significant alarm is when the High Court injuncted against the employer for failure to consider fair procedures when dismissing the employee during the probationary period. Now, this caused significant alarm because, as we know, the function of the probationary period is for both the employer and the employee to see are they a suitable fit, and for a cliche, no strings attached, that it's easier, to test out the relationship. So Justice Costello in the Court of Appeal very helpfully clarified the situation and reversed the High Court decision. What Justice Costello said was that the High Court did not put enough emphasis on the fact this was during a probationary period. So there's different standards that apply. She clarified that unfair dismissals don't happen during the probationary period if the probationary period is written in the contract and is for less than a year. She also made sure to clarify that this was a situation of poor performance rather than any allegations of misconduct. And the final thing that I'm going to talk about that happened in 2021, if any of you are familiar with employment law in Ireland, it'll be of no shock that I'm talking about the Zalewski case. So the Zalewski case caused shockwaves, once again, in the employment law world in Ireland. And just to give you a brief overview of what happened, there was an employee who was bringing a claim against his employer to the WRC for unfair dismissal and payment in lieu of wages. The date was set and there was some scheduling issues. So when Zalewski went to have his day in front of the adjudication officer had actually already dismissed the claim. It was heard on a previous date. Aggrieved, Zalewski brought a judicial review against the Workplace Relations Commission Act 2015. Now, this act founded the WRC, and since its founding, the WRC has had quasi-judicial functions, which meant declaring this body unconstitutional would have huge ramifications and cause so much confusion over decisions they have made over the past 6 years. So this was such a tense matter for everyone in the employment law, wondering was it going to be found constitutional, what would be the impact if it was unconstitutional. But the Supreme Court narrowly decided that the 2015 Act was constitutional, but, and there's a big but, that as the WRC were administering justice on behalf of the courts, it had to be to the same standard as the courts. So the procedures of the WRC needed to change. So typical proceedings that were held in private, they're not allowed anymore. All WRC proceedings have to be held in public. Decisions, if anyone in the audience has ever tried to look for a WRC decision, you can know it can be quite challenging because they were all anonymized, because you'd be looking for an employer versus an employee. These are no longer anonymized, and evidence can also be taken under oath. So these are huge changes, and the jury is still out what impact this will have on future cases before the WRC. Will this change behaviours? Will the type of case being brought change? So this is a huge development, and we are expecting legislation any day now to amend this 2015 Act. Now, there are the three things that have happened in 2021, three things that are in the pipeline for 2021. First up is gender pay gap reporting. Now, for those of you dialing in from the UK today, this is a concept I know you're all very familiar with, but this is coming to Ireland. It's not a matter of if, it's a matter of when. This bill is in advanced stages in our government approval process for legislation. And what this bill requires is for employers to report on the mean and median hourly remuneration of part-time and full-time employees for men and women. Also requires employers to report on the mean and median bonuses for both men and women, and also the percentages of men and women receiving bonuses and benefits in kind. Not only this, but employers will also be required to give an explanation if there is a gap between these figures for men and women, and also to detail any measures they're taking to reduce this gap. Now, I'm sure a few of you are sitting like, who does this apply to? Well, currently, as the bill stands, it's going to apply to employers with over 250 employees. But now don't sit back and take a deep breath if you're under this threshold, because the next year the threshold is lowering to 150, and the next year it's lowering again to 50 employees. So this is going to have huge implications on employers and having to report. And I'm sure you're wondering as well, what happens if we don't comply? Well, the Irish Human Rights and Equality Commissioner can reply to the Circuit Court to enforce compliance. Employees can also take their employers to the WRC for not complying, and also the Minister can actually assign designated officers and empower them to investigate and report. And so what we'd advise any Irish employers to do right now is to look at internal procedures, look at internal mechanisms, and consider how you're going to comply with this reporting and set up internal channels on how you can fulfill this request. Next, the next development that's going to be in 2021 is statutory sick pay. So quite unusually, Ireland is one of the only member states that doesn't actually have statutory sick pay. Further, only 44% of Irish employers actually offer sick pay. Now, Ireland does have state illness benefit that kicks in if you've been out of work, out sick for 4 days, but there's no employer requirement to pay sick pay. Well, this is all changing, as you can imagine why this is in my things that changes for 2021. So there's actually been a movement to get statutory sick pay. And this issue has really been thrusted into the spotlight by NPHET, that is our National Public Health Emergency Team, in particular Dr. Ronan Glynn, who is our Chief Medical Officer, as COVID has really highlighted this gap, and a lot of blame has been attributed by NPHET and the CMO for outbreaks because there is no employee security through statutory sick pay, and employees who are sick are going into the office to pay these bills, to ensure that they have a cash flow. So we actually got a glimpse last week, if any of you've seen any headlines, of what the statutory sick pay is going to look like. And when it's introduced, it's going to be 3 days sick pay leave for employees. So this is going to cover the gap between when an employee gets sick until state benefit kicks in. So what payment is this going to be? It's going to be 70% of an employee's wage, capped at €110. And employees who apply for this are going to have worked in the organisation for 6 months, and they're going to have a sick cert. Now, this 3 days threshold is going to be extended to 10 days by 2025. It was in the consultation report, there was a clear divide between employers and employees over this issue, because employers obviously have had a really, really tough year, and this is an additional financial burden. So for now, this is going to be introduced at 3 days, but it will be extended to 10 days. And now the final thing I'm going to talk about is whistleblowing and the Protected Disclosures Amendment Act. Now, not to toot our own horn, but Ireland actually was one of the first member states to have a protected disclosures. And why this is being amended is because there's an EU directive that is coming into force, so we need to change our national legislation in order to comply with the EU directive. Now, this directive has to be implemented by December 2021, so it's definitely coming in 2021, so it definitely should be on your radar. And what this does is it extends the whistleblowing protections. So typically, a protected disclosure is a disclosure by an employee with a reasonable belief of an employer committing a wrongdoing. That this wrongdoing can be committing of an offence or failure to comply with legal obligations. And this amendment will extend the scope of employees who are protected under this legislation. So the extension will go to volunteers, will go to trainees, and it will even go to shareholders of companies who make protected disclosures. What this legislation also requires is that for companies with over 50 employees, formal procedures will have to be in place. And these formal procedures are that a protected disclosure has to be acknowledged in 7 days, it has to be investigated, and the person who made the protected disclosure has to be updated on the situations 3 months after they have made the disclosure. What this Act also does is that establishes a protected disclosures office in the Office of the Ombudsman. And right now, what we've seen is the general scheme for this Act, which is like the subheadings, giving us a taste of what's going to be in the Act. But Minister Michael McGrath has actually indicated that this Act will also contain the reversal of the burden of proof. So if an employee alleges that they have been penalised because they made a protected disclosure, it is up for the employer to prove that they haven't. So going forward, what we really would advise is that employers in Ireland especially take an abundance of caution when dealing with employees because of this reversal of the burden of proof. And we also would advise all employers to start looking at internal procedures and seeing are they compliant with this EU directive. Now, really interestingly, if you look at the 3 developments that I've just talked about that are happening in 2021, statutory sick pay, the gender pay gap, and now the increased whistleblowing measures, you can really see that there is a push for increased social responsibility on both a national and EU level. Now, for us internally in our team, we have seen a huge increase in interest in ESG, environmental and social governance, by clients, by employers, by businesses. So it's amazing to see that this ESG momentum is not only being pushed by employers and companies, but also on an EU and national level. And this trend will be further evidenced by Richard later on in this talk. But for now, I'll hand you over to Kira, who's going to talk about pensions updates in 2021.
Thanks very much, Emer. I suppose anyone who's aware of the Irish pensions industry will know that I was in the same position Emer was a few years ago, saying IRPS is coming, it's coming in January 2019, don't worry, Ireland is going to transpose it soon and it will change the entire pensions industry. But alas, we had to wait. So we finally, on the 22nd of April 2021, got our IRP2 regulations. So apologies for anyone not based in Ireland who is like, have they not transposed that yet? But no, we are here now. We are looking at this. So I'm going to today just talk you through an overview of the regulations and just some of the key changes for you to be aware of if you're an employer or a trustee of an occupation pension scheme. And then we're going to talk about some of the practical issues for yourself. Just, you know, how can I get up to speed on this and what are the next steps? Next slide, please. So I suppose the key changes we're going to talk about today are fitness and probity requirements relating to trustees and key function holders. This new system of governance that the Pensions Authority is responsible for. And we're also going to talk about whistleblowing, which Emer also spoke about. Many of the changes that we see in the IR2 regulations have been well signposted to us in advance by the Pensions Authority. So as Emer was talking about, we see the ESG in relation to investments, but because we had a delay in the transposition of the regulations, those ESG requirements have been somewhat overtaken by other EU legislation, such as the sustainable finance regulations. And anyone who's working in the financial services scope will also be very well aware of the fitness and probity requirement. So there's the introduction of similar requirements has taken place here relating to trustees and key function holders. And I suppose in the governance, one of the key things that the Pensions Authority has told us for many years is that they're going to take a proactive approach to the supervision of pension schemes going forward once the IR2 regulations come into play. So that means they're going to be looking at the governance standards and the ability of trustees to meet the risks which attract their schemes. Next slide, please. So I suppose the fitness and probity requirements, many of these were already in place in relation to trustees, but we see there's been some slight changes here. So obviously trustees must be of good repute and integrity. So there was previously requirements that anyone who was convicted of fraud or was it bankrupt, could not be a trustee. And these have been now extended to include anyone who is convicted of such an offence abroad, and it also includes money laundering offences. So if you're guilty of an offence in another EU member state or in the UK, that will also mean that you cannot be a trustee here in Ireland. There must be a minimum of 2 trustees, or where there's a corporate trustee, there must be at least 2 directors. Now, the trustees are now required to have collectively adequate qualifications, knowledge and experience. This is an area that the Pensions Authority flagged to us well in advance. And, you know, we've seen the regulations have seen some aspects of that introduced, but I think we're awaiting further guidance from the Pensions Authority just to clarify other aspects. So, for instance, in relation to the qualifications piece, the government had previously indicated that a level 7 qualification would be required, but we haven't seen that in the regulations, so that may be to come. There must be collectively adequate experience, so that means at least one of your trustee board must have 2 years experience as a trustee of an occupational pension scheme. And I suppose it's important to note here that the Pensions Authority can demand evidence of this fit and proper requirements. We do need some further Pensions Authority guidance on these adequate qualifications and knowledge, but I think the key point for yourselves to look at if you're a trustee or an employer here is to now start assessing your trustee board. Do you meet the requirements that have been set out in the regulations in relation to qualifications, knowledge and experience? And if you don't meet those requirements, some proactive steps will need to be taken, such as maybe an appointment of a professional trustee alongside your current board, or you may wish to entirely replace your trustee board. But this is just a key issue for you to start looking at. And I suppose these fitness and probity requirements that we talked about in relation to trustees, they're also going to apply to key function holders. So the Pensions Authority flagged to us many times in advance that there was a requirement to appoint these key function holders in the areas of risk management, internal audit and actuarial. And the key function holders must also meet these fitness and probity requirements. So they must have adequate qualifications, knowledge and experience to properly carry out their specific key function. And the Pensions Authority can also request evidence to verify this. So I suppose the key function holders are a key part of governance. Next slide. So this is the main area. We call this the Part 6 governance requirements in relation to the occupational pension schemes. So the occupational pension schemes must now, there must be an effective system of governance which covers all the functions and activities that are required to manage the scheme. There must be an allocation of responsibility. And a key issue that we've seen in the regulations, which was not signposted in advance, but which many in the pensions industry sought, was there is a new element of proportionality. So that means that any effective system of governance or any of these areas in which certain standards of governance must be met are now subject to the requirement that they are proportionate to the size, nature, scale and complexity of the scheme. So this is the Pensions Authority taking note that if you have a pension scheme with 1 billion in assets, it's not the same as a pension scheme with 100,000 in assets. So they're going to, when they assess whether you're meeting the requirements of the regulations, they will take into account the proportionality. So is your system of governance sufficient to the size of your specific pension scheme? There's also policies and procedures which are required to be put in place. And again, these were well flagged to us in advance. These are the risk management, the financial services, the internal audit, outsourcing. And a lot of these policies and procedures, anyone who's working in the financial services industry will have seen them previously. The policies are subject to a triennial review. We don't have any guidance yet on the content of what is to be included in this, but we expect to see this in the coming months from the Pensions Authority. One of the first policies which we do have to have in place is a remuneration policy, which is due by the 31st of December of this year, so 31 December 2021. And this covers trustees and their staff, key function holders, and scheme management where it's outsourced. Again, the remuneration policy must be proportionate, but it must disclose publicly relevant information. another issue that was well flagged to us is the own risk assessment. So schemes must carry out an own risk assessment, which is proportionate to the size of their scheme, which will identify the risks which the scheme is exposed to in the short and long term. And again, this will be reviewed every 3 years. Where a scheme is looking to outsource key functions of the management of the scheme, they must notify the Pensions Authority now in advance, and there must be written agreement, which is essential. And I suppose one of our second key documents which will be needed for an occupational pension scheme is this compliance statement. So this is a statement which is due by the 31st of January 2022, which confirms whether the scheme complies with Part 6 governance requirements. So the Pension Authority is going to start looking in January to see whether occupational pension schemes are complying with this system of governance. And I suppose we're going to talk about in a few more slides just the actual practical implications of the Pension Authority not having given us guidance yet on that. So how can we expect to meet the requirements and set out in a compliance statement in January how we're complying in 2021 for something where we don't have full guidance yet, but we'll talk about that at a later stage. And I suppose one of the other things to note is just where the Pension Authority now see any issue with their governance of an occupational pension scheme, they can issue advisory notices, or they can ask for an external report to be done. So these are where the pension schemes authority note that there is a risk or a liability with a pension scheme, and they request further information, or they require the trustees to take some proactive step to remedy that risk. Next slide. And I suppose, how are the Pensions Authority going to find out about these risks? So similarly to Emer's slide, we've got new whistleblowing requirements. So once we've appointed these new key function holders, they have an obligation to whistleblow to the Pensions Authority in certain circumstances. So if there's always been whistleblowing requirements in the Pensions Authority, but they mainly related to the material misappropriation of assets or the fraudulent conversion of scheme assets. But now, if there's a substantial risk of non-compliance with a material provision of the Pensions Act or any other relevant act, there's an obligation on a key function holder to bring that to the attention of the Pensions Authority, where they have notified the trustees of the scheme and they have not remedied that breach within 21 days. So I think, key point here for yourself as an employer or as a trustee is just, highlight to your trustee board, hey, if you have a key function holder appointed now and they're reporting issues of risk or concern to your trustee board, that you have 21 days to remedy that before the key function holder is required to make a report to the Pensions Authority. So I suppose it's going to give a bit more impetus to trustee boards to ensure that they're keeping on top of things. Next slide, please. So I suppose we've talked about some of the key requirements of the regulations. And I think this is a handy little slide that we've done up here just to note some of the key dates for yourself. The main thing to note is that the regulations run to 73 pages. And on the face of the regulations, they look as if the system of governance, the key function holders, fitness and probity requirements, a lot of these requirements have come into effect on the 22nd of April 2021. But hold on, it's Ireland, we will take our time. So we've also had some further information from the Pensions Authority to state that, contrary to what the regulations say, they don't expect everyone to be fully compliant with the regulations just yet. So they have issued, obviously they have reserved their right to prosecute where there is a breach of the Pensions Act, but they have noted that until 1st of July 2022, they expect master trusts and all new schemes to be fully compliant. But the Pensions Authority does not expect all schemes to be fully compliant with IRAP until 1 January 2023. So I suppose the key thing to note is, look, we have our regulations where we've been told that we're getting further guidance this year. We know that there is some policies due in December and January of this year, but let's start looking at the requirements of the regulations. Let's start looking at what you can do and what practical implications there are for yourself as employer of occupational pension schemes. Next slide. So I suppose what we in William Frye are seeing and the experience that we have to date is what the regulations have kind of seen. What we've seen is just a professionalisation of trusteeship and the consolidation of pension schemes. So many employers are coming to us and asking us to look at their occupational pension schemes and assess, you know, how am I going to comply with the requirements? What do I need to do? And as a first step, what we're advising our clients to do is look at your pension schemes that you currently sponsor. So how many schemes have you got? Now include your main staff scheme, include any legacy schemes, look at executive schemes that you have for executives, and also look at any schemes, you know, that you may think, oh, that's deferred scheme, or that's an insured arrangement, or I couldn't possibly be the trustee of that. And then they start pulling out documentations, and yes, they are trustee of 25 different occupational pension schemes. So, you know, we really need to get on top of your pension schemes, speak to your HR manager, ask your pension advisors to provide you with all the governing documents so you can ascertain exactly what pension schemes do I have? Am I the trustee of those pension schemes? If you are the trustee of those pension schemes and you are an employer, you know, you may wish to appoint a professional trustee, or you may wish to appoint a professional alongside a trustee board that you have, but you need to kind of start looking at your trustee board and looking at what schemes you have. And I suppose a key thing for you to be aware of is that as an employer, you would indemnify the trustees for any risks relating to the occupational pension scheme, and many employers will also be paying the costs of it that are applicable to a pension scheme. So if you have 25 pension schemes, that's 25 times the indemnity for the trustees, 25 times the cost of meeting the requirements of the regulation. So you want to kind of get ahead of the curve, see what you have, see what your trustee board is, and, you know, just consider, do I want to consolidate them all into one scheme? Do I want to move into a master trust? And just also be aware of the fact that the Pension Authority recently came out and did a review of master trusts, and currently they found that none of them met the requirements of IRB2. And I know they're due to meet the requirements before the rest of the occupational pension schemes, but you may just want to get some advice before you enter into any agreement relating to a master trust. And I think that's it for me. That's I'm going to hand over to Richard. So just, yeah, you know, let's all start looking at our occupational pension schemes, and we're just going to talk about flexible working and COVID guidance.
Thanks, Ciara. I hope everyone can hear me. So yeah, as Ciara has mentioned, I'm going to be speaking about, you know, recent guidance that the Irish government has released, as well as the Health and Safety Authority, and I'm also going to speak about flexible and remote working developments. Next slide, please. So as you can see there, the Work Safety Protocol, the Irish government has released various iterations of this, I suppose, document, and it really, I suppose, sets out the up-to-date medical, you know, guidance and health and safety measures to reduce the spread of COVID-19 in the workplace. And while the current version, which was released in mid-May, it largely follows the guidance that was there previously. And there are three, I suppose, areas that it develops a little bit more on, and they're on the next slide. And so the first is in relation to vaccination. So the protocol, you know, emphasizes that the decision whether to get a vaccine or not, you know, it's a voluntary decision, you know, taken by the employee, and it's, you know, they get it from the state-operated program. So I suppose it's important that the employers, the protocol emphasizes that they provide employees with, you know, up-to-date information around the state vaccine program, so they can make informed decisions about whether or not to obtain it. And I suppose another thing that the protocol emphasizes is that vaccination is not an alternative to the other measures that are mentioned in the document, such as, you know, continued use of physical distancing, face coverings, and, you know, measures like that. Then in relation to ventilation, the guide, I suppose, again, it emphasizes that this is a key way to really minimize the risk of COVID-19 in the workplace. Because poorly ventilated areas can, I suppose, mean that the virus remains suspended in the air for longer periods, and therefore, you know, increasing the risk that someone's going to contract it. So the guidance really emphasizes that employers should encourage employees to open windows, whether that's in offices or vehicles, as well as turning off any air ventilation systems that recirculate the air in a building. And then in relation to antigen testing, the protocol, I suppose, recognizes that an additional preventative or protective measure that employers might look to implement would be, an antigen testing regime. But before employers do that, there are various factors that the protocol says should be taken into account, whether these are, from a technical perspective, but also, I suppose, ensuring that workplace relations, continue to operate well, for want of a better word. So I suppose the process for introducing any kind of regime that you might look to introduce, really it's ensuring that you engage with workers before implementing it, and really consult with them so that everyone is aware about why you're looking to introduce it. Maybe looking at things like frequency of testing, whether it be internally or externally provided, as well as who exactly might be covered by it, whether it would just be employees or others like visitors or contractors. Another thing to consider is that I suppose generally the protocol recognizes that it's a voluntary testing regime that it would be suggesting employers implement if they're going to be putting in a regime. And as such, there should be an agreement really between workers and the employer around what's to happen where in a situation where someone doesn't want to be tested. And then another factor then to consider is that I suppose under health and safety legislation in Ireland, employers have to prepare risk assessments of workplaces over which they have control, and these would really identify the risks that are, I suppose, evident in the workplace, and then publish, or I suppose prepare and publish a safety statement setting out, what these various risks are, and then how you're going to mitigate those. So really, to review and update those is, I suppose, a key piece of guidance in the protocol. Next slide, please. So that's really, the protocol in a nutshell. You have then the Health and Safety Authority has released interim guidance. You will have heard Emer mention the Health and Safety Authority earlier. It's released interim guidance for employers and workers on fitness for work following a COVID-19 related absence. Next slide, please. So you'll see that it covers various different scenarios, such as returning to work from a suspected case, or where you have an employee with a confirmed case but no health complications, or you might have an employee who has had the virus and has had health issues arising from that, and they're unable to return to work. How you might deal with that kind of situation. So in relation to an employee who has a suspected case or a confirmed case without complications, really the interim guidance, I suppose, suggests that an employee should be providing some form of certificate, whether it's a self-declaration form or maybe from their GP, for example, to declare that that they are COVID-free. And then upon their return, you as the employer then would be I suppose giving them training and information around any updates to COVID prevention measures that have been implemented, any updates to the risk assessments or safety statement, those kinds of measures. Then when you have someone who is unfit to return to work, it generally follows the approach that you will, I suppose, generally apply where you have an employee with any kind of illness and they're unable to return. So really you're kind of communicating with them throughout. You're trying to see if and when they can return. Usually that would involve engaging an occupational health provider or speaking to the employee's doctor. Then closer to the time when they can return, you'd be looking around what reasonable accommodations you can implement, whereas that might be, for example, I suppose, the tasks that they might do, or the environment they're working in, what changes can be made to make it that bit easier for them to return to work. This was the interim guidance. It's really at pains to say in some respects that, you know, the guidance should be considered alongside the existing sickness and absence procedures that are in place in a particular organization, because, you know, there's no one size fits all with this guidance or the protocol for that matter. You know, each organization really has to consider these sets of guidance and, you know, how they can apply within their own workplace and their own practices. So that's really it on the, I suppose, COVID guidance side of things. So now I'm going to speak about remote and flexible working. So as you know, you're all very well aware, most of us, you know, were forced to go and, you know, work from home from March 2020. And while employers and governments, you know, had been looking at this, certainly the Irish government had been looking at it, you know, before the onset of the pandemic, you know, it has really accelerated, you know, the developments in this area. So the Irish government released its national strategy on remote working in January 2021 and looked at various issues around, you know, how to really embed remote and flexible working in the Irish workplace. So two measures that I'm going to talk about that came from this strategy are the right to disconnect and the right to request remote working. Before I do that though, as you can see on the slide here, I'm going to talk about Family Leave and Miscellaneous Provisions Act 2021. And I feel that it really dovetails quite nicely with this whole idea of, you know, making flexible working a bit more easier for workers, particularly I suppose in this context for parents. So the Family Leave Act 2021, it made changes to parents' leave and adoptive leave. It was recently introduced, and it, I suppose, firstly in relation to parents' leave, while originally each parent could avail of 2 weeks leave within the first year of birth or placement of a child, the 2021 Act has extended that to 5 weeks now. And there's a state benefit payment available for those 5 weeks. And it can be taken within, you know, 2 years rather than 1. Then in relation to adoptive leave, there was an anomaly in the Irish I suppose legislation dealing with adoptive leave, whereby male same-sex couples couldn't avail of the leave. And, you know, this provides up to 40 weeks you know, leave. So it's a substantial entitlement that a cohort of people were excluded from. So this 2021 Act has made changes and allows now couples to, including male same-sex couples, to select which of them, you know, should be able to avail of the adoptive leave, and then the other can avail of paternity leave, which is separate to parents' leave, but it's a period of 2 weeks as well. So on to the next slide, please. I'm going to talk about the right to disconnect and the code of practice that was introduced. So I suppose from, it hasn't been so long ago when we've been moving away from this, you know, 9 to 5, clock in, clock out, traditional form of working. And it's really from technological, you know, developments that we've really seen, you know, big changes in this area. But while there have been, you know, considerable advantages to it, there have been, you know, issues that have arisen, such as, you know, an always-on culture and a blurring of the line between home and work lives. And I suppose this has caused stress for a number of workers. So the Irish government introduced this code of practice on the right to disconnect. And you'll see on the next slide, you know, the 5 key aims for this code and what it tries to do. So hopefully they'll come up here now. 1 to 5, it should appear. Great. So as you're, I suppose, reading through those, I think there should be another one there. Number 5, yes, there you go. So while they're, I suppose, while you're perusing those, the right to disconnect, or the code, I should say, it defines the right to disconnect as an entitlement or an employee's right to be able to disengage from work and refrain from engaging in work-related electronic communications such as emails, telephone calls, or other messages outside normal working hours. And I suppose there's three components to the right to disconnect. The first is the right not to work routinely outside your normal working hours, the right not to be penalized for refusing to work outside those hours, and also a duty to respect another's right to disconnect. Significantly, I suppose the code, it emphasizes that employees can be required to work outside their normal hours, but this should be the exception rather than the rule. And I suppose a key takeaway from the code, and you'll see it on the next slide, is that there are obligations on employers and employees. So, for example, on the employee side of things, you have things like they should be aware of their own work pattern and to take remedial action if they feel that their own well-being is being impacted, and they should also consider and maintain and protect their own safety, health, and welfare, as well as of others and other employees. Then, for example, on the employer's obligation side of things, you'll see there that they should provide detailed information to employees on their working hours, ensure that employees take adequate rest breaks, and that they keep adequate records of working time and rest breaks, because this is a legal obligation that they have to follow or comply with. I suppose another key facet or aspect of the code is that it's not legally binding. So strictly speaking, there's no legal right or entitlement to the right to disconnect, but it's a code that can be taken into account by the civil courts and employment tribunals in Ireland, in cases to which it relates. So if an employer isn't complying with the code, it could find itself on the back foot trying to explain, why it wasn't complying. So we would certainly advise that best practice would be to comply with the code where at all possible. So the key actions then, what are employers, what should they do even from the code? So the first thing really is to prepare a right to disconnect, and this policy. And there's a template in the code itself, but we would say that this should really be tailored to fit and suit each organization, because obviously each organization is different, they have different work practices, and so to make it effective, it should really be tailored. And the code itself then, in addition, emphasizes that consultation should be undertaken with employees, again to ensure it's fit for purpose really. And linked to that then is training that should be provided on the policy to managers and employees, so that they are aware of the content of the policy, as well as how it's going to work in practice. And as I've mentioned, there is this legal obligation on employers to record time and rest breaks. So obviously it becomes much more difficult to do so when employees are working from home and they're working flexibly and remotely. So we would certainly say employers should review their time recording mechanisms to ensure that they are fit for purpose. And then finally, reviewing contracts of employment templates and email and other policies is certainly a good idea, because really once you have this right to disconnect policy, it should really be, I suppose, referred to in your other documents where relevant, and that your other, particularly your policies, like your email policy and your maybe bullying and harassment policies, for example, they refer to and take account of this right to disconnect. Finally then, on the flexible remote working side of things, I'm going to talk about the right to request remote working. Next slide, please. So yes, so you'll see there the quote there, right to request remote working is a particularly relevant issue at the minute, because once we all start going back to the workplace after COVID, certainly employees will be looking to ensure that they can at least potentially have some of their time, where possible, to be able to use that to work remotely or flexibly. So you'll see in the next slide that this was, as I said, it was part of the National Remote Working Strategy And in that, the strategy said that the right to request remote working, that it's going to be brought in via legislation in Q3 of 2021. And I suppose this really comes about from an EU directive on work-life balance, which requires member states to introduce national legislation around providing parents and carers with a right to request remote working. So I suppose it's important to emphasize that it's a right to request it, and it's not a right to remote and flexible working. So we would expect the legislation, when it comes through, to set out a framework for requesting and approving or refusing requests for remote working. And again, there's no one size fits all for this, remote working. It really depends on the role and the employee does, as well as, what work the organization, does. And the government had a public consultation on, the right to request remote working and to feed into the drafting of the legislation. And this closed on the 7th of May, just gone by. So the government is reviewing those submissions at the minute. Then really, I suppose, to conclude, you've probably gathered from the presentations here today that, employment law and pensions, it's rife for, development. There's changes all the time, but certainly during this COVID pandemic, we have seen an acceleration of these developments. So we would certainly advise employers to really, I suppose, get ahead of the game and be as proactive as you can in grappling with these changes, because they are coming down the track. And to really be as prepared as you can be before their introduction. So I'm going to hand over to Catherine now to manage the Q&A part of the session. Thanks for your time.
Great. Thank you, Richard. Thank you, Ciara and Emer. I think that was a great deal of very practical information in a very short space of time. So probably a lot of things for us to think about. And of course, if anything particularly resonated with you, if you have any questions, Ciara, Emer and Richard would be more than happy to hear from you after the webinar with anything you'd like to discuss further. In relation to questions, though, we have a couple of questions, and the first one I'll come to you, Richard, if that's okay. And it touches on something that you were just talking about there, which is the recording of hours, which is a really thorny topic and one that we have had a lot of client queries about whilst employees have been working from home. Because even though the Act has been around since 1997, the Organisational Working Time Act, it has really kind of come to the fore in recent months, I think would be fair to say. Added to that, then the right to disconnect policy talks about, making sure employees take breaks, and there is reference to a two-way street in terms of employees also making sure that they avail of their breaks. But a very long-winded way of asking you the question, Richard, which is there any data on how employers are tracking working hours? I haven't come across any data myself. I don't know if you have, Richard.
I haven't seen any myself, how they're dealing with it currently. I know with the WRC, or the Workplace Relations Commission, it has a template timesheet that they ask that they've released, that I suppose is the basic thing that employers should do. But obviously that's not entirely practical, because a lot of times it would mean that employees physically filling in a form, maybe giving it to their manager, and it gets scanned in, and whatever else. I mean, there are systems in place, software-wise. We're all used to those kind of clock in, clock out type scenarios or situations. But really, I suppose the emphasis should be on reminding currently at the minute, because we can't strictly see them working away, or more importantly, when they're taking their rest breaks in the context of this question. So it's really just reminding employees about their entitlements to take rest breaks, and to really come to you if they aren't being able to take their rest breaks, and then really figuring out why that is, and trying to remedy that.
Yeah, and probably a good way to, sorry, Richard, probably a good way to remind employers of that, to remind employees to do that would be by way of your right to disconnect policy. So if that talks about the need for employees to do that, it's a good way to put that out there, I guess. The problem being, though, I suppose, even though we're working in this very digital environment and working remotely, it's quite a stark legal obligation that is there and has to be complied with, unfortunately. So would be happy to work with anybody on the webinar that has questions about that for sure. Emer, if I could come to you now in relation to the statutory sick pay. Now, I know we're going to have to wait to see what the legislation actually says, but we have a question here as to whether we anticipate that there will be a number of waiting days before sick pay is payable, similar to the waiting days applicable to the illness benefit.
Yeah, that's actually a really interesting question, because that was actually a topic that Leo Bracker touched on last week when he was detailing what the statutory sick pay scheme entails. So the purpose of this statutory sick pay and why it is 3 days is because it's going to kick in immediately for 3 days, and then an employee will be entitled to their illness benefit on the 4th day. So it's to really, there's no waiting period, and it's to really cover employees until state benefit can kick in.
Okay, perfect. Ciara, if I can come to you, it was a great overview in terms of the increased responsibilities and obligations, but obviously this will come with a cost. So
Yes.
a question has arisen as to who will pay for this increased compliance.
So I suppose in the first instance, many current trustees and rule will say that the employer is responsible for the costs. But what we are tending to see, and I think what we will see in future, is that any increased, there will be increased costs across the board, which will apply also to employees. So we see a lot of employers that are moving their employees from a standard DC scheme into a master trust, but yet there's, you know, really increased costs for the member in that master trust. So there are kind of just some hidden costs there that you may want to be aware of that can impact on the pension benefits of your employees. So, you know, just always take that into consideration. But I suppose that's why we advise, like, try and consolidate and, you know, get your house in good order now, so that you're not replicating those costs across a number of different occupational pension schemes.
Perfect, thank you. We have a couple of minutes left. So Richard, if we could just briefly touch on vaccinations, because that's such a hot topic at the moment, obviously. So it is voluntary, but can employers do anything to encourage employees to get vaccinated?
Yeah, I suppose I'd be wary of the type of incentives that you'd be looking maybe to introduce. Largely, I suppose the safest thing would be, you know, providing information, as I said earlier, around, you know, the benefits of getting the vaccination, and almost doing as much as you can to almost kind of bring them to the door, if it were, you know, what the process involves, registration, what the appointment's like on the day. I've certainly heard of instances where, you know, maybe bonuses might be considered to try and get employees, you know, vaccinated, as well as maybe entering in a raffle or teas and coffees and things like that. But the problem with, or certainly the risk, I should say, with going with that route is that, you know, you might have certain employees who shouldn't, or have been given advice, I should say, medical advice, not to get a vaccine. They're automatically then kind of excluded from the kind of bonuses and things like that. And then you're running into issues around, you know, potential discrimination. So I suppose it's just to be careful of the type of incentives that you'd be looking to use.
Okay, good advice, thank you. Okay, so that brings us up to 5:30, so that hour went incredibly quickly. Again, I'd like to thank everybody who has stayed with us and joined us. I'd like to thank Dan and his team in Mondac. I'd like to obviously thank Ciara and Emer and Richard for all the information that they've given us today. And to the attendees, I hope you get to enjoy the right to disconnect and log off soon and have a lovely evening. So thanks very much to everybody.
Thanks, Catherine.
Thank you.
Thanks, Catherine.